So a very good morning to everyone who's logged in already, and welcome to another seminar under the iProbono Legal A to Z for NGO series. I'm Priya Vatwani. I'm a senior program officer and a lawyer at iProbono, and I lead our capacity building work. Before we dive into the discussion today, I would like to take just a few minutes to give a quick introduction to our expert speakers for today, as well as iProbono. As most of you might know us, we are a social justice organization whose mission is to enable people to access their rights. We have been working in India for over 10 years and have a multifaceted approach, which includes legal representation, advocacy, training, and capacity building efforts. Under our litigation vertical, we provide free legal representation to vulnerable communities with the focus on cases involving child sexual abuse, forced labor, trafficking, children in conflict with law, and residents of informal settlements. Along with that, we engage in targeted research and policy advocacy initiatives as well. We also work towards strengthening civil society and their capabilities through our in-house legal team, alongside a network of over thousands of lawyers in India who offer pro bono legal support to NGOs. And finally, under our capacity building vertical, we organize seminars, develop resource materials on regulations that govern the nonprofit sector. The Legal A to Z series for NGOs is one such initiative catered specifically towards CSOs and NGOs. And those who would like to know more about this series and access videos of previous seminars, I will be sharing details on the chat box because we have to keep the introduction quite concise this time around. Our team also conducts trainings on internal policies such as POSH and child protection policies, and also delivers legal awareness sessions on various issues concerning child protection, domestic violence, housing laws, to name a few. I will be sending all our details on the chat box, and you can access them. You can visit our website and even reach out to us if you have a request. I will now introduce our speakers for today, who are lawyers from Touchstone Partners, which is a law firm having expertise in cross-border transactional matters. They advise several Fortune 500 corporations, sovereign wealth funds, institutional investors, and financial sponsors. Their core practice area: corporate mergers and acquisitions, competition law, employment law, and of course, data privacy and protection. I'd like to welcome Anuj Bhatia first, who is a partner at Touchstone and advises on diverse corporate matters, including mergers and acquisitions. He also regularly advises on a number of international clients on data privacy and protection. We then have Shruti Bhatt, who is a counsel at Touchstone and focuses on antitrust and merger control matters, as well as data privacy and protection matters for both domestic and international clients. And then we have Antara Deshpande and Mahak Goel, who are both associates at Touchstone, and again focus on general corporate matters, mergers and acquisitions, and of course, data privacy and protection for domestic international clients. The Touchstone team has always been so supportive of iProbono, and I've done many pro bono projects for us. So a big thank you for them for that, and also for coming on board to discuss this crucial and very timely topic with us. So that was a very brief snapshot of both iProbono and Touchstone. But in case you'd like to know about either of us, I'll be dropping our website links on the chat box. To give everyone an idea of what's in store for the next 1.5 hours, the Touchstone team will be taking us through data protection laws, focusing on compliances for NGOs specifically, along with a comparative analysis, keeping in mind the new act that has come in. The last 25 to 30 minutes will be open for a Q&A discussion. So I will request everyone to reserve their questions for that segment. During the Q&A, of course, participants can raise their hand. You can unmute yourself and ask your question, or if you want, you can put them in the chat box during the course of the session, and I will take them through during the Q&A. The team also has a scenario interaction prepared. So during that segment, you can also do the same, raise your hand and unmute yourself and interact, or put your responses on the chat box. And also, in case there are any questions we cannot take at the end of the seminar due to time constraints, please feel free to write us over email and we will respond to you then. The session is being recorded, so the recording will be put up on YouTube soon. With that, I will hand over to Shruti and Anuj, and they will take it forward. And I'm just dropping all the details on the chat box. Thank you, everyone.
Thank you very much, Priya, and the rest of the iProbono team for giving us an opportunity to work with you on this again. I think everyone will be relatively aware of the fact that personal data has been a hot topic in India in recent years. It was recognized as a fundamental right in a Supreme Court judgment a few years ago. And I think there's been legislation that has been promised along the way for a long time, but it is finally here in the form of the new personal data law, which has received parliamentary approval and presidential assent, and is now expected to be rolled out in the coming months. So I think, now I think, especially in this digital age in which we live, personal data is utilized by all sorts of organizations in all sorts of ways. Of course, you have the big tech companies, and they are, a lot of in the news a lot of the time for the way that they use and sometimes don't use correctly our personal data. And this has become a very significant topic both in India as well as in the West, where we've got significant, fines being imposed under, for example, the European law of GDPR and so on. But it's not just big tech and corporates that should be aware of these requirements. I think it would be fair to say that they will certainly apply to a large extent to NGOs as well. NGOs collect, as you will know better than I do, you all collect personal data in many forms and from various stakeholders, whether they are volunteers or contributors or donors, or indeed the individuals that perhaps your organization is trying to assist, whether they are children or people who have suffered from crimes and so on, etc. So there's a lot of, I think, personal data that you all as NGOs access and use and process. So I think we will try and cover that in the next few minutes. And I suppose the other things that you will need to be aware of is the increasing requirement and importance needed to get appropriate consent for using the data that you have, and also the specific purposes that you use the data for. Under the current regime, which frankly was conspicuous by its absence, there was no real teeth in enforcing any of the requirements in relation to data, but this has now changed under the new law, which is expected to be rolled out shortly. There will be a data protection board established, which will have the ability to impose significant penalties and so on. Some of you may also have links with other countries, and therefore may have concerns and questions around the cross-border transfer of personal data that is with you. And Shruti, Antara, and Mehek will cover that during the course of the next hour or so. So I think without further ado, let me hand over to Shruti to basically run us through the more significant aspects of the new law, and wherever possible, we will try and correlate that to what will be of particular relevance to you all as NGOs. So I'll hand over to Shruti now and let her take us through the new law.
Thank you so much, Anuj, and thank you so much to all of you for joining in for today's session, and thank you to the iProbono team as well. It's been wonderful always working with you. So what we're going to do in today's session is that we are going to cover two data protection regimes. The current data protection regime, which primarily comprises of the Information Technology Act and rules in respect of reasonable security practices and procedures for sensitive personal data or information. These are the primary laws that we look at governing data protection at present. And of course, the new Digital Personal Data Protection Act 2023, which was just passed by the two houses of parliament last month itself. It was also assented to by the President of India shortly after being passed in the parliament. And we're going to be discussing the various compliance requirements, doing a comparative analysis as such. And before we begin, just like Anuj mentioned, basically the current data protection regime is quite rudimentary in nature. As he said, there's no enforcement agency as such. So enforcement actions are not really seen in the current context. But all of this is set to change with the introduction of the DPDP Act, as we will keep referring to it in the course of this session. What we understand from media reports is that the rules in respect of the DPDP Act are actually finalized or close to being finalized and will probably be notified sometime soon after the end of the G20 summit, which is taking place this weekend. And so far as the transition period is concerned, it's quite likely that a short transition period of about, say, 6 months is likely to be provided, though it still remains to be seen whether for entities that are not required to be GDPR compliant, or for smaller entities, especially non-profits and stuff, where it's likely that if all actions have been just India based and GDPR has not come into the picture, then hopefully a slightly longer transition period may be provided, but all of this is quite uncertain at the moment. So let's also get into the comparison. So in the course of this session, just to be very clear, there are certain other aspects that we will not cover in the interest of time, which is the Digital India Bill, uh, and also the National Data Governance Framework Policy. These are in the pipeline or they're in draft form, so we're essentially not going to be covering these. But of course, the SPDI rules and the DPDP Act will be covering those. Now, before we actually get into the comparative analysis, there are certain terms that we wanted to highlight before we begin, just because we will be using these throughout the course of the session. So we would like you to understand these before we begin. Under the IT Act and the SPDI rules, basically there are two definitions that keep popping up, and these are the terms that we will be using. So personal information is information that relates to any individual which helps identify such individual. And sensitive personal data or information, or as we will keep referring to it as SPDI, is a higher or more stricter, more sensitive category of personal information, and usually comprises of information such as passwords, medical records, physical, mental health conditions, sexual orientation, biometric data, financial data like credit card details, bank account details, and such. Um, SPDI is, of course, it's a smaller subset of personal data, so there are certain provisions that are applicable only to SPDI, not to personal data in general. SPDI does not actually comprise of any information that is already in public domain or which is available under the RTI Act. So that is one aspect that must be noted. So far as the new regime is concerned, there are four terms that we will be constantly using. One is personal data, which is again similar to the position under the SPDI rules, information about an individual which can help identify such individual. Then there's data principle. Data principles are the individuals to whom personal data relates. What the DPDP Act does is that it also clarifies very helpfully what who the data principles will be in case of, say, children or persons with disabilities. So in case of children, their parents or lawful guardians will also be considered as the data principles. And we will come to all of this in a while. We do know that this was a very widely asked question. So we will be coming to children related data. And in case of persons with disabilities, it would also include their lawful guardians. So far as data fiduciaries are concerned, data fiduciaries would be people who either by themselves or with someone else will determine why personal data needs to be processed and what exactly will be the means of processing of that personal data. So they are the people who will be in charge of understanding why personal data is even required. And data processors will essentially be third parties who will help process personal data on behalf of data fiduciaries. So as will be very evident from the slide, unlike the SPDI rules, which have two categories of personal data or information, the new regime, the DPDP Act, will actually not have any such categorization. So similar treatment will need to be accorded to personal data across the board. So regardless of where personal data is, what kind of personal data is being collected, whether it's being collected for a particular purpose or under a particular legislation, if it is personal data, then all the provisions will apply, unless and until there are certain carve-outs or exemptions which will need to be assessed on a case-to-case basis. So coming to probably the first and most important point in any legislation is the applicability of the law. So what exactly does the IT Act and the SPDI rules, to whom do these apply? So the SPDI rules are actually applicable to body corporates, which includes companies, firms, sole proprietorships, or associations of individuals that are engaged in commercial or professional activities. But what we actually tend to do is to read this a lot more widely and to even consider not-for-profit activities within this ambit, as we don't think that the intention of the legislation was to accord narrow protection so far as SPDI is concerned. Also, so far as information is concerned, I mean, these rules cover personal information, including SPDI, that is collected from individuals, which is either processed or stored in a computer resource that is owned, controlled, or operated by a body corporate. So the scope itself is quite wide. What the DPDP Act does is, thankfully, it adopts a more clearer approach. So far as the persons to whom it can apply, it basically says data fiduciaries and data processors can be a whole range of persons or entities. It can be individuals, Hindu undivided families, companies, firms, the state, or even any other artificial juristic person. So they do have a catch-all uh, clause in this respect. What the DPDP Act does is also that it's applicable both within and outside India, and the legislation clearly clarifies what situations it would be, in what situations it would be applicable. So within India, the DPDP Act would be applicable to the processing of personal data where such data is collected in digital form, or it's collected in non-digital form but is digitized subsequently. But where there is a lack of clarity is that whether the DPDP Act will cover non-digital personal data that is not subsequently digitized. So when we say this, we're thinking of personal data, for example, that is covered in very old financial papers. So from the language of the DPDP Act, it may be assumed that such kind of data should not be covered, but there's no clear specification in this regard. So far as its applicability outside India is concerned, it would be applicable to digital personal data that is processed outside India if the processing is in connection with any activity which is related to offering of goods and services to data principals in India. So there must be an India nexus as such. The DPDP Act also has certain situations where it says that it would not be applicable. So say personal data is processed for personal or domestic use, then the DPDP Act would not apply in this regard. Or even where it's publicly available personal data. For example, if a person themselves put out their personal data out on the internet, then it would not be applicable. Or if, say, any person is obligated to make such personal data public because of any legal requirement, then such personal data would also not be governed by the provisions of the DPDP Act. So moving on from the applicability and going on to probably what is one of the what forms the bedrock of probably any data privacy framework as such, that is consent. So consent is covered under both the SPDI rules as well as the DPDP Act. What the SPDI rules specify is that in case an individual's SPDI is being collected, then their prior written consent needs to be obtained, and the SPDI rules specify that these can be This can be obtained by way of either letter, email, or fax. And the consent should be just with respect to the purpose of usage so that the individuals can consent to this. But so far as personal data that is not SPDI is concerned, there is no consent requirement as such. So in such case, the only aspect that would need to be complied with is that reasonable steps would still need to be taken to ensure that the individual whose personal data, not SPDI, is being collected knows that their personal information is being collected. With respect to the DPDP Act, this threshold becomes a lot more stricter because it applies to personal data in general. So the DPDP Act requires the consent of data principals for processing of their personal data, unless and until such processing is required for certain legitimate uses, which are spelled out in the Act. So, and this is something we will just come to in a very short while. But in case it is required for certain legitimate uses, then no consent will be required. Also, what the DPDP Act does is that it provides a lot more clarity on what consent should look like. And there's a 5-point principle that it provides. Basically, consent would need to be free, specific, unambiguous, informed, and unconditional. There also would need to be a very clear affirmative action on part of the data principal who would be providing such consent. And any consent would be limited to the specified purpose for collection of personal data that is actually necessary for giving effect to that purpose. So because of this specified purpose requirement, what we're in fact considering is that maybe once the DPDP Act is operationalized, the relevant provisions are operationalized, it may be the case that a blanket consent may no longer work. And organizations, including NGOs, would need to be very targeted in their consent requests, very clearly specifying what the purpose is and making sure that the data being collected is actually necessary for that purpose. And also, care would now need to be taken that no extra information is being collected that is actually not necessary for any specified purpose. An additional requirement under the DPDP Act is that every data principal would need to be provided with the option to view the consent request as well as the privacy notice that we'll come to shortly in English as well as in any language specified in the 8th schedule to the Constitution of India, which are currently 22 in number. So this particular language option requirement could potentially be an extensive exercise. So coming to the privacy policy or the privacy notice that we just talked about, again, a very, very important aspect of compliance under data privacy frameworks in general. So the SPDI rules provide that body corporates or any persons collecting information on their behalf should have a privacy policy in place for collection of personal information, including SPDI. They're also mandated to ensure that anyone who has provided personal information under a lawful contract should be able to view the privacy policy. And technically, the rules also specify that such privacy policy should be made available on the website of the body corporates or persons collecting information on their behalf. Thankfully, the SPDI rules also provide certain guidance on what exactly need to be reflected in the privacy policy. This includes statements of their practices and policies, the type of personal information, including SPDI, that will be collected, the purpose of collection of such information, if any information will likely be disclosed to third parties, and also any reasonable security practice and procedures that will be adopted to ensure that the information is safeguarded. So that with respect to the SPDI rules. What the current regime, what the new regime or the DPDP Act provides is that data fiduciaries would need to give a notice to data principals, again, similar to a privacy notice, informing them of the personal data that will be collected, the purpose for collection of such personal data, the manner in which data principals can exercise their rights under the DPDP Act, and how they can make complaints to the Data Protection Board that Anuj had talked about in his introduction. So such privacy notice needs to be provided either at the time of requesting for consent or prior to that. What also needs to be done, in fact, once the act is operationalized, is that in case consent has been previously obtained prior to the operationalization of the DPDP Act, then data fiduciaries would need to give a fresh consent as soon as reasonably practicable to data principals for once the relevant provisions have come into force. However, thankfully, the DPDP Act also provides that data fiduciaries would be permitted to continue processing personal data until and unless the data principal expressly withdraws their consent. And while there is no express requirement under the new regime to separately publish this privacy notice on the website, as is the case for the SPDI rules, because a lot of color is required to be provided to the DPDP Act by way of delegated legislation or rules, it's quite possible that this requirement to publish it could be provided under any of the rules that will be issued. So moving on, since we are talking about consent and privacy, we have to cover refusal to consent and also withdrawal of consent. These are actually covered under both the SPDI rules and the DPDP Act. So far as the SPDI rules are concerned, it provides that individuals must be provided with the option to not provide their personal information or SPDI prior to such information being collected. And also individuals can at any point of time withdraw their consent by making a request in writing. Under the DPDP Act,
you can't do anything about that. Whatever you've taken. You have to repay back the money. So you start working as soon as possible and repay the money.
I'm sorry.
Hi all, I'll just request everyone to be on mute, and we'll take questions and comments at the end. Thank you. You can go ahead, Shruti.
Thank you so much. Okay, fine. So far as the DPDP Act is concerned, because consent needs an affirmative action, the data principal needs to agree to provide consent. So this also means that data principals can refuse to provide consent at such stage. However, because there is a legitimate use clause under the DPDP Act, in such cases, no consent of data principals would be required for processing of personal data. And we'll just come to legitimate uses very, very shortly. So far as withdrawal is concerned, withdrawal of consent is also permitted. And in fact, the new regime specifies that the ease of withdrawal would need to be commensurate with the ease with which the data principal had provided their consent in the first place. And also where a data fiduciary has, say, availed of the services of a data processor, the withdrawal would need to be communicated to the data processor by the data fiduciary, who would need to ask them to cease processing of personal data within a reasonable time unless it's required by law. So far as legitimate users is concerned, as we've said, I mean, these are situations where the consent of the data principal would not be required. And these situations are exhaustively listed and include, amongst others, processing of personal data for responding to medical emergencies involving, say, a threat to the life or immediate threat to the health of a data principal or any other individual. For taking measures to provide medical treatments during epidemics, disease outbreaks, etc. for taking measures to ensure the safety of people or to provide assistance during any disasters or any breakdown of public order, for provision of subsidies or benefits by the government, subject, of course, to certain conditions, and for processing of personal data for employment purposes or for safeguarding an employer from loss or liability. So this would include prevention of corporate espionage, maintaining confidentiality over trade secrets, intellectual property, classified information, or for providing any services or benefits sought by a data principal who is an employee. So this is so far as consent is concerned. Coming to the next aspect, in fact, again, there were a few questions on this. How long does information need to be retained for? So you have obtained consent of people, you have gone ahead and processed the data, you have it in your database. And NGOs, of course, have significant amount of data in their databases. So how long do you need to retain this for? And the position is not very dissimilar under both the current and the new regimes. So the SPDI rules provide that SPDI should not be retained for longer than is necessary or is otherwise required under any law for the time being in force. And even under the DPDP Act, data fiduciaries are required to erase personal data upon the earlier of either withdrawal of consent by a data principal or as soon as it is reasonable to assume that the specified purpose for which the data was collected is no longer being served. However, in case personal data is required to be retained to comply with any law for the time being in force and it's required to be retained for a longer period of time, then such legal requirement would need to be adhered to. So say, the DPDP Act provides some beautiful illustrations, one of which is in case a person closes their savings account with a bank and withdraws their consent to processing of personal data by the bank. But RBI regulations require that the bank stores personal data of individuals or former customers for 10 years post closure of any accounts. Then even though the bank would no longer need to actually process that data principal's data and the consent has been withdrawn, because there is a legal requirement to retain data for 10 years post closure, the bank would still need to go ahead and retain that personal data for that period of time. Coming to the next aspect, which is correction of data. So sometimes it does happen that personal data may be incorrect or it may need to be updated. And both the current and the new regimes provide for such corrections to take place. The only difference as such is that under the SPDI rules, a data fiduciary would or a body corporate would actually not be responsible for the authenticity of the personal information, including SPDI. However, as can be seen from the slide, under the DPDP Act, data fiduciaries would actually be required to ensure completeness, accuracy, and consistency of personal data in case of two situations. One is where the personal data processed by such data fiduciary is likely to be used to make a decision that affects the data principal, or such personal data is likely to be disclosed to another data fiduciary. So in such case, the original data fiduciary needs to ensure that the information is correct, accurate, and complete. After all such information has been collected, a very important aspect is with respect to security of such data. So both the data protection regimes require that reasonable security practices and procedures be implemented for safeguarding data. So the SPDI rules specifically mention in this regard that body corporates and persons collecting information on their behalf should have a comprehensive documented information security program and information security policies, which should contain managerial, technical, operational, physical security control measures that are commensurate with the information assets that are being protected, as well as the nature of the business being carried out. Under the DPDP Act, it's again quite similar. Data fiduciaries are required to implement appropriate technical and organizational measures to ensure that they're in compliance with the provisions of the DPDP Act. And they're also required to take security practices and measures as such. Under the SPDI rules, quite interesting to note is that there's a technical requirement for carrying out audits of the security practices and procedures. And these audits are required to be carried out on an annual basis or as and when the processes and computer resources are upgraded. But such an audit requirement is actually applicable only to significant data fiduciaries under the DPDP Act, at least expressly. Moving on to the next aspect, which is disclosure of information to third parties. The SPDI rules are quite clear on this, that the prior consent of individuals needs to be obtained prior to disclosure of information to third parties, unless such disclosure has already been covered in a contract with that particular individual, or it is required to comply with any legal obligation, or where such disclosure is required to be made to the government or pursuant to an order under law. And what happens is that body corporates and persons collecting information on their behalf are mandated not to publish SPDI. So unless and until it is covered in the disclosure aspects, the consent aspect, or any of the other carve-outs, they cannot publish SPDI. And where third parties receive SPDI, they are mandated not to disclose it further under most circumstances. So far as the DPDP Act is concerned, when we say processing of personal data, processing as a term includes disclosure of information. So any disclosure of information to third parties would imply, it's implied that it would require the consent of the data principal, unless of course it falls under any of the legitimate use categories. The new regime also requires that where data fiduciaries would like to obtain the services of a data processor to process personal data on their behalf for any activity related to offering of goods or services to data principals, then they can do so only under a valid contract. Along with disclosure comes another important aspect, which is transfer restrictions or transfer enabling provisions. So both the current and the new data protection regimes envisage the permissibility of transfer of personal data outside India. So far as the SPDI rules are concerned, they permit transfer of SPDI outside India if the country to which it is being transferred ensures the same or better level of protection than is required under the SPDI rules. With respect to personal data that is not SPDI, there are no such restrictions and it can be freely transferred. So far as SPDI is concerned, the transfer of SPDI must either be necessary for contractual performance or it must be consented to by the information provider. The DPDP Act, on the other hand, actually provides that transfer outside India would be permitted unless and until the country or the territory to which the personal data is proposed to be transferred is on a negative list, which will be issued by the government. But in case there is any law in India that provides for a higher degree of protection or which restricts transfer of data, then such stricter law would be applicable. So for sorry?
You can continue, Shruti. I think someone just unmuted themselves.
Okay, sure. So it just in case of the DPDP Act, then just to give you an example, say the DPD you want to transfer certain payment provider related data outside India to a country which is permitted, which is not on the negative list as such. However, under the RBI regulations, such data needs to be located in India itself. It cannot be transferred outside India. So that means you will need to adhere to the stricter RBI regulations rather than the more liberal DPDP Act, so far as transfer of such data is concerned. The last point that we will be covering is appointment of officers/representatives as a comparative analysis. And under both the current and the new regimes, there are certain officers or representatives who are required to be appointed. The SPDI rules provide for the appointment of a grievance officer by the body corporate, and the name and contact details of such grievance officer needs to be published on the website of the body corporate as well. So far as the DPDP Act is concerned, data fiduciaries are actually required to appoint an authorized representative who would be responsible for responding to any communication from data principals for exercise of their rights under the DPDP Act. For entities that will be classified as significant data fiduciaries, something we will come to very shortly, they would need to appoint a data protection officer at the point of contact for grievance redressal and to respond to any communication for data principals for exercise of their rights under the legislation. And in each case, such officers' business contact details would need to be published in a manner as would be prescribed by way of rules. And these contact details would also need to be included in the consent request to the data principals. And all of this, of course, also means that under both the current and the new regimes, there is a requirement for data fiduciaries to provide a grievance redressal mechanism. Now, apart from these, there are certain provisions that the DPDP Act has come up with, which we wanted to highlight, like certain provisions that we feel would be relevant. The first and probably the most important one we realize is the processing of children's personal data. While the SPDI rules do not have anything specific in relation to children's data as such, what the DPDP Act does is it specifically addresses processing of personal data pertaining to children, and children are defined as individuals who have not yet achieved 18 years of age. So if a data fiduciary intends to process the personal data of a child, they would need to obtain verifiable consent from the parents or the lawful guardians of the child. And I mean, such a verifiable consent requirement is also extended in case of persons with disabilities, in which case the consent of their lawful guardian would need to be obtained prior to any of their personal data being processed. So far as restrictions are concerned, the DPDP Act restricts data fiduciaries from undertaking processing of personal data that is likely to cause any detrimental effect on the well-being of a child. And I mean, what detrimental effect could look like is not exactly defined, or there are no factors provided under the main act as such, which means that the interpretation of this term would be more subjective and may need to be decided on a case-to-case basis. So while it does cater for a more evolving definition of what detrimental effect could possibly look like, from a compliance perspective, it could probably be a more difficult exercise since you need to be very careful about this. In addition, data fiduciaries under the DPDP Act are restricted from undertaking tracking or behavioral monitoring of children or targeted advertising that is directed at children. However, the Act thankfully does provide a couple of carve-outs as such, specific carve-outs for processing of personal data of children. One is where the government is satisfied that a data fiduciary has ensured that the data of children is processed in a manner that is verifiably safe, in which case it can notify an age above which that data fiduciary would be exempt from the requirement of obtaining verifiable consent and even from the obligation to refrain from undertaking tracking, behavioral monitoring of children or targeted advertising. Another carve-out is where the verifiable consent requirement and the restriction on tracking, behavioral monitoring, etc., would not be applicable to certain classes of data fiduciaries or for such purposes and subject to such conditions as may be prescribed by way of rules. So, of course, we would now need to wait for the rules to see how they provide color to these children-related requirements under the DPDP Act. Coming to the next one, which is enhanced obligations of data fiduciaries and significant data fiduciaries. So enhanced obligations of data fiduciaries are, of course, what we've already discussed, some bits that we will also cover going forward. We've already seen that the new regime is a lot more stricter. There are going to be higher fines. What the new regime also does is that it introduces a specific category of significant data fiduciaries. And these will be notified by the government, and the factors that the government will take into account to determine whether a data fiduciary is actually a significant data fiduciary will be the volume and sensitivity of the personal data that is processed, the risk to the rights of the data principles, security of the state, and several certain other factors as well. And significant data fiduciaries will have certain additional obligations under the DPDP Act as compared to data fiduciaries in general. So this would involve carrying out periodic audits and even data protection impact assessments. What a significant data fiduciary would also need to do is they need to appoint a data protection officer who will be based in India. And such data protection officer will be responsible to the board of directors or any other similar governing body of the significant data fiduciary. And they will, of course, already discussed, they would need to be a point of contact for the grievance redressal mechanism under the DPDP Act. The third aspect we wanted to cover was personal data breach reporting. So currently there is a mechanism in place for reporting of personal data breaches or data breaches in general, to be frank. Currently, any data breach reporting is to be made, is to be filed with the Indian Computer Emergency Response Team or the CERT-IN. And any data breaches are required to be initially reported within 6 hours of the incident coming to a person's notice. So far as the DPDP Act is concerned, it specifically provides that in case of personal data breaches, because of course the legislation covers personal data, data fiduciaries would be required to notify the Data Protection Board as well as any affected data principals about such breaches. And till now, there has been no such requirement to notify affected individuals. So this is a new requirement that has been brought up under the DPDP Act. And it's also because there is already the certain reporting requirement. It's not 100% clear how they will work off each other. And that is something that remains to be seen. The next aspect we wanted to cover are the information nomination rights of data principals. So under the DPDP Act, data principals will have certain rights, including the right to access a summary of their personal data that is being processed, including the processing activities being undertaken with respect to such data, and the identities of all data fiduciaries and processors with whom the personal data has been shared. However, there are certain carve-outs with respect to these rights as well, and these would need to be assessed as and when a situation, as and when a particular case comes up. And apart from the right to, say, get their information corrected and get their information erased that we've already discussed, data principals under the DPDP Act will also have the right to nominate any other individual who will, in the event of the data principal's death or incapacity, will exercise their rights in line with the provisions of the DPDP Act. Another very welcome move under the DPDP Act is the setting up of an independent regulatory and enforcement body, which is the Data Protection Board of India. So the Data Protection Board will fill a very important void so far as enforcement is concerned in India. It will have a chairperson and certain other members, and they will need to meet certain criteria, including possessing special knowledge or practical experience in certain fields. So far as the functions of the Data Protection Board are concerned, they would primarily be able to inquire into personal data breaches, issue directions to data fiduciaries to remedy such breaches. It can receive complaints from affected persons and also impose penalties for non-compliances. But so far as the legislation is concerned, it currently does not provide any leeway to the Data Protection Board to sue or to take up any action, which means that there would need to be a complaint to the board before it can take any action. The DPDP Act also sets out an appeal mechanism, quite a detailed process in this regard, and it provides that any person who is aggrieved by an order of the Data Protection Board may file an appeal with the appellate tribunal, which for the purposes of this legislation will be the TDSAT, or the Telecom Dispute Settlement and Appellate Tribunal. There's one more mechanism which is also covered just in the interest of time, very briefly. The DPDP Act also provides a voluntary undertaking mechanism by way of which persons can provide a voluntary undertaking to the Data Protection Board at any stage of proceeding that's going on before it. And this undertaking can be, for instance, to take certain actions or to refrain from certain conduct. However, the discretion to accept this voluntary undertaking lies solely with the Data Protection Board. Lastly, we wanted to cover the blocking part of the central government. And essentially, this is a situation where a data fiduciary has been penalized twice. So monetary penalty has been imposed twice on such data fiduciary. And the Data Protection Board feels that it's in the interest of the general public that they should not access any information that is generated or transmitted by such data fiduciary, in which case the Data Protection Board can file a reference with or make a reference to the central government, and they can tell them to block access, and the central government, before taking any action in this regard, can provide an opportunity to the data fiduciary of being heard, record its reasons in writing, and see whether any blocking part does need to be exercised in such case. Now, we've covered these additional relevant provisions, and probably the important aspects that are now left are the exemptions and consequences. So the SPDR rules actually don't really provide for any specific exemptions as such, but the DPDP Act does have an exhaustive list of exemptions. Some of these exemptions are more wide-ranging and provide for situations where the entire legislation would not be applicable, whereas others are more focused and more targeted. But largely, these exemptions are legal, regulatory, or security related. And these would need to be assessed on a case-to-case basis. And just in the interest of time, probably we'll just make sure that just there would be certain data fiduciaries or classes of data fiduciaries to which certain provisions of the legislation would not apply. But again, because all of this is required to be notified yet, or it is required to be operationalized, these would need to be assessed on a case-to-case basis. So far as non-compliance is concerned, while the IT Act and SPDR rules and even the certain directions on data breaches, etc., do provide for certain consequences as are listed out on the screen. The truth is, because there is no effective enforcement agency as such, enforcement action is not really seen in the Indian context. But the DPDP Act is set to change this. It provides teeth in this regard. So just in case the Data Protection Board determines that a breach of the DPDP Act has taken place and it is significant, it can give an opportunity to the data fiduciary of being heard, or the relevant person of being heard, and impose a monetary penalty. And the monetary penalty amounts are very significant, of course, especially compared to the current regime. So to be very fair, the board, before imposing a monetary penalty, will take into account certain factors, such as the nature, gravity, and duration of the breach, the type and nature of the personal data that has been affected by the breach, and mitigating action if any has been taken. But so far as the penalty amounts are concerned, the highest one is up to, and up to is like, of course, it's the outer limit of 250 crores for failure to take reasonable security safeguards to prevent personal data breaches, up to 200 crores for failure to comply with provisions in relation to processing of personal data of children, or for failure to notify the data protection board or affected data principals about personal data breaches, and so on. For data principals, separately, the DPDP Act sets out certain duties, and any failure to adhere to these duties can attract a penalty of up to 10,000 rupees to the relevant data principal. So these were the provisions of the DPDP Act as compared with the current regime. We will now have certain scenarios that Antara will take us through, and we would love for all of you to please participate. Antara, over to you.
Thanks, Shruti. We would love for all of you to please participate in this section and please let us know your views in the comments. So as you would see on your screens, the first scenario is that your organization is working towards enabling financial independence and self-reliance in women. In this regard, you are conducting a survey in a local area, which involves collection of the name, age, phone number, and education details of such women. So the first question is, do you need consent to collect such data under the SPDI rules and the DPDP Act? Please let us know your views in the comments. So I see some yes, many yeses actually.
A lot of yeses.
So as you would have guessed, this is fairly straightforward. Under the SPDI rules, though, this information would qualify as personal information and not SPDI, since name, age, phone number, etc. are not covered under the definition of SPDI. Therefore, no consent requirements under SPDI as such. That is the current regime. But of course, under DPDP Act now, name, age, and phone number would constitute as personal data. And collection of such data would require issuing of notice with details of what is being collected, why exactly is the data being collected, and of course, taking of explicit consent from these women whose personal data is being collected in this case. Just flagging out once again that this consent has to be free, informed, unconditional, and unambiguous. Basically, every possible detail has to be mentioned in the notice and has to be extremely explicit. Next question is, for how long can you retain this data? I'll just give everyone some time to write down their answers. So I see some people answering 10 years or till it is required or mandated by the government. So as previously mentioned by Shruti as well, generally in case of SPDI, the information cannot be retained longer than that is necessary by or when it is required by the law. But since this information, that is name, age, etc., is not SPDI, under the current regime, the retention requirement is not applicable in this case specifically. But under the DPDP Act, the data fiduciary can retain the data till whichever of these events occur earlier. Firstly, till the time the women withdraw their consent for processing of such data. So firstly, withdrawal of their consent, or till the time it is reasonable to assume that the person that the purpose that is specified in the consent notice is being served, unless the retention is required under the law. So therefore, it's quite clear that under the new regime, the data fiduciary cannot really retain the data till whenever it desires, unlike the earlier position under the SPDI rules. Moving on to the next part of the scenario. A few months later, one of the women who was part of the survey approaches your organization requesting for a correction in the spelling of her name. What should be your course of action? So the course of action here would primarily be that the data fiduciary will have to correct this information in their database. And so in this case, the organization has the duty to correct this person's personal data on her request. Coming to scenario B. So your organization is collecting and using medical data of adolescents in order to understand whether certain therapies would be beneficial to their age group. Do you need consent to collect such data under the SPDI rules and the DPDP Act? And whose consent is required to be obtained? So yes, someone has mentioned that the legal guardians and parents' consent would be required. That's correct. So under the SPDI rules, as mentioned earlier, health data would constitute as SPDI. One thing to note under the SPDI rules, though, is that there is no specification made for taking consent of children or persons of certain age. So technically, under the SPDI rules, a written consent is required to be taken under the current regime from the relevant person, which in this case would be a child, regarding the purpose and use of data. But the DPDP Act, since it has special provisions for processing of children's data, it now requires an organization to take verifiable consent of the parent or the lawful guardian in this respect. Next, you set up an online advertisement account to ensure that children in the above age group who are surfing the web can view that you're offering therapies for adolescents. Do you think this would be permissible? What should be your course of action? Someone has mentioned that targeted advertisement is not allowed and depends on the permission as per the DPD. So yes, that's correct. In this respect, the Act clearly provides that personal data of a child cannot be processed for targeted advertising purposes. But as mentioned by Shruti not so while ago, that the Act has special carve-outs in this respect. And we think that maybe that would be relevant for NGOs. The first thing is that the requirement for taking verifiable consent and prohibition of targeting itself may fall off for certain classes of data fiduciaries or for processing of children's personal data for certain specific purposes, which may be prescribed by the central government. And the government may also directly exempt certain specific data fiduciaries for these requirements after verifying that processing is done in a verifiably safe manner. But since there are no parameters yet, it is yet to be seen how it pans out for NGOs. So yes, in short, the Act does not permit. However, we still have to see how the rules and regulations are framed in this respect. So if organizations have to operationalize the online advertisement account, they should first seek legal advice before going ahead with this, because the rules and regulations will need to be assessed in this case. Moving on to scenario C, and I really apologize if I'm moving too fast. I'm just being a bit conscious of time here. Scenario C is that your organization is utilizing the services of a third party for storage of financial information of certain individuals availing of your services. You, however, get to know that someone has been able to hack into their computer resources and extract the data of 50 individuals. What is the course of action under the current data protection regime? So people are saying that we need to notify the authority, yes. And there are certain requirements within 6 hours, yes, that's correct. So we know that financial information would constitute as SPDI. So in this, in cases of data breaches, the enforcement mechanism under the current regime is quite ruthless, as mentioned by both Anuj and Shruti. Or one can say that there is no real enforcement mechanism as such under the current regime. But legally, under the IT Act, when a breach is found to have caused wrongful loss or wrongful gain, it would expose the organization to pay damages by way of compensation. And in addition, as mentioned by some people in the comments, that certain directions of 2022 would also apply, where you would require to notify certain within 6 hours of noticing this incident. This was the position till now. However, under the new regime, there are multiple courses of action that one would have to take. Firstly, notify the data fiduciary. The data fiduciary would have to notify the Data Protection Board of India and each data principal that is affected by this breach. So if 50 people are affected in this case, all 50 will need to be informed. The time period to report such breach is not prescribed under the Act yet, but we assume that it shall be prescribed by the board with the procedure for informing the breach. But we'll have to see how that also pans out. It is also important to remember again here that failure to report such breach to the DPB and the affected data principals would expose organizations to very high level of penalties, and that may even rise to 200 crore rupees. Apart from this, the certain requirements are still there, and parallel reporting will have to be undertaken. Coming to the second part of the scenario, which is very relevant, you check your contract with the third party providing the information storage services and note that there was no obligation imposed on the third party for ensuring security standards. What actions can this open your what actions can this open your organization to? So yeah, there would be some penalties. This is a very important aspect because under the DPDP Act, the data fiduciary has the sole responsibility to prevent any personal data breach. So even when non-compliance has taken place by a third party or a data processor, the liability will arise on the data fiduciary. And such a situation can open the organization to significant penalties, as mentioned in the comments, that may rise up to 250 crore rupees, which of course is determined by various factors such as the nature and gravity, the repetitive nature of the breach, or whether any mitigating steps were taken by the data fiduciary or not. So these are certain parameters that would decide the penalty amount, but it might reach till 250 crores as well. However, what is certain is that the enforcement mechanism under the new regime intends to hold the data fiduciary liable on occurrence of the current regime. So, of course, the data fiduciaries that are collecting or that are deciding the purpose of collection have to be very careful under their contracts here. So these were some practical situations we thought were relevant for our session today. We hope this was a helpful exercise, and after so much information, I'm sure there are a lot of questions from the attending organizations. So let's take some questions now.
Thank you so much, Antara, and thank you, Shruti and Anuj as well. I'm going to quickly start with the questions that have already come in on the chat box. So, and if we have time later, you can unmute yourself and raise your hand as well. But I'll just take the chat box question first. So, anyone who from the Touchstone team who wants to answer this can do that. Pradeep has a question. In the DPDP Act, consent requirements, what does it mean for consent to be at the same time, both specific and unconditional?
So specific what? Sorry, Anuja, would you want to take this?
No, please go. Sorry, I was going to say please answer. Yeah.
So specific, as we mentioned, we think that because the consent needs to be taken for a very, very specific purpose, it cannot be a blanket or a general consent. So if you need to collect data for purposes A, B, C, you need to spell them out that these will be collected for A, B, C. And unconditional would mean that basically no strings attached. They need to consent fully.
Okay. If you have any clarification, need further clarification, Pradeep, just put your comments on the chat box. We'll get back to you. Nilaba has a question. We have been collecting data since the 90s. So do we need to provide notice as well as the consent request to everyone whom we've collected data from since then?
So yes, you will, because the DPDP Act will require consent to be in place unless and until you're collecting data for a legitimate use, which will need to, of course, be assessed on a case-to-case basis. So you will need to again obtain their consent, and that needs to be obtained as soon as reasonably practicable. But what the DPDP Act also provides is that you can continue to process personal data till the data principal withdraws their consent. But essentially, you will need to comply with the consent request and the privacy notice requirement. Yes.
Yeah.
Okay. Next question is, personal data includes photographs taken during official meetings also, and what other apart from KYC and basic details, and also for the beneficiary society, which we are keeping in our report, how to ensure the same. I think they're talking about all the photographs needed for KYC and their reports that they prepare.
So because sorry, Anuj, please go ahead.
I was going to say again, the bedrock, and I think the fundamental principle that and the starting point for everything here should be always consent. So if you are proposing to use photographs like this, or for KYC purposes, or for publication in your reports, etc., now I think the starting point and the safe course of action would be to get specific consent for anything that you're proposing to use this for.
Thank you, Anuj. Next question is by Pradeep again. Who is held liable for inaccuracies in personal data? Data principal or data fiduciary? It seems like usually principals are not themselves the ones recording the data, but a fiduciary is on devices or systems that they build or operate. So liability becomes tricky.
So in this case, so under the current regime, at least, it's the data principal or the individual who would be responsible. The body corporate collecting the information would not be responsible. But under the new regime, it's only in a couple of situations where the data fiduciary would be responsible for ensuring accuracy, consistency, etc. That is, if you are going to be taking using that personal data to take any action in relation to the data principal, or if you're going to be disclosing that information further to another data fiduciary, then you need to make sure that that data is correct, accurate, and consistent.
So yeah, so just to add on to what Shruti is saying, which is absolutely correct, there are really two aspects to this. There is an obligation generally on data fiduciaries to ensure that the information that they have is accurate, but equally, on the obligation section where there's obligations on the data principals, the individuals, they are under an obligation not to provide any information that is completely inaccurate or makes them impersonate someone else, etc. So it's a slightly, it's probably a bit of an obligation on both, but to the extent that the average person provides information to, let's say, a bank or an insurance company, it's on the onus is on the bank or the insurance company to make sure that the information remains accurate and current. I hope that answers the question.
Thank you both. There are two questions relating to schools, so I'm just going to club them. Praveen is asking that is there anything specific mentioned? I think he's talking about the act itself, about schools or groups working on education when some behavioral monitoring may be required. And Gautam has a similar question. How would this law be applicable on information collected by schools run by NGOs?
No, the Act doesn't have anything specific about schools per se. and the educational aspect. Of course, the law itself is quite a short act, and there will be lots of rules and regulations coming out in the near future. Let's see if they deal with any of these aspects. But to answer the question, there's nothing specific at the moment dealing with schools and education-related stuff. The only provisions really are the provisions that Shruti talked about relating to minors and so on.
Thank you. I think a lot of questions are coming from the comparative analysis between GDPR and DPDP. I'm just going to combine a few maybe.
Yeah.
One question is, if an Indian NGO is using or promoting a foreign data fiduciary who is GDPR compliant, what are the chances that DPDP would bring in significant challenges due to the differences between GDPR and DPDP?
So, I think my response to that would be that if you are GDPR compliant, then you are probably, I would say, a long way along the way to being compliant with the new law in India, because GDPR is quite a sophisticated regime, and typically, at least at this stage, even before this new law, the view has generally been taken that if you comply with GDPR in terms of security measures, you're probably all right for Indian law purposes. So I think that will probably continue. But I think care should be taken to ensure that you do reflect the requirements of the new law as well in your compliances, because the new law is not identical to GDPR. It's similar, of course, but not identical. So there may be a few tweaks there. And that's going to be, I think, an area of analysis that will come up a lot in the near future, something that we will also do to see, what, if anything, GDPR compliant companies need to do to become also compliant with the Indian law.
Thank you. Again, a lot of questions coming in on how we should collect consent. People are asking if there is any particular format for collecting it. What's the best way to do it? We're collecting data from adolescents, from women. Is there any difference between collecting data from different stakeholders or beneficiaries?
Again, sorry, without wishing to dodge the question, this will probably be fleshed out in the rules. But I think, again, the safe course of action, given that consent will be the bedrock of all data collection, generally speaking, with these exceptions, I think the onus is going to be on the data fiduciary, the people collecting the data and using it, to show that they received this unambiguous and specific consent. I think I saw, a very good question actually in the chat, which I hadn't thought about if you're collecting consent from someone who perhaps can't read or write, then I think, again, a practical solution would be to make sure perhaps you video it or something, because the onus will be very much on you as the collector and fiduciary to show that you did in fact get proper consent.
Great. Rohan has a bunch of questions. I'm just going to go one by one. Being the IT person, may I be the data fiduciary, or the child protection team will be the data fiduciary of the children data that we collect?
So I think if you are all part of the same organization, you're in the IT department, but there's a section dealing with the children, then I think the organization itself would be considered the data fiduciary. So it would be, the organization itself, and not necessarily a particular department within the organization. I just saw a question pop up saying, is oral consent not enough? It needs to be recorded in some form or fashion so that you can demonstrate to the authority, if necessary, that you did in fact receive that oral consent. So, as I said, probably need to have some sort of video recording of it if necessary to show that you got oral consent.
And the second part of Rohan's question was, which I think is a very practical question that most of us might have, that should we take consent from parents or children to use their photos on our website or any social media? May it be verbal, or what is the best form?
Yeah, the short answer is yes. Yep. Please do. Please, my suggestion would be tread carefully here, especially when you're dealing with minors and so on. So make sure you get very, very unambiguous consent, and you only use it for the purpose that you got consent for.
Jayraj has a very technical question, I would assume. In an assisted mode of operations, can agents provide consent regarding their customers on behalf of whom they are conducting financial transactions?
No, you have to get it from the individual. But again, sorry, I hope I understood the question correctly. Is that a person who's unable to provide the consent themselves because they're differently able to something?
I think, Jayraj, if you can unmute yourself and ask that question or explain more, it will be helpful.
Yeah, thank you, Priya, and thank you, Mr. Anuj. So this is a question regarding using of a platform on the Android devices. So we have an agent network, a female agent network, and it runs on an assisted mode that the customers don't transact there on their own, but they come to these female agents and they, on their behalf, these female agents only do the transactions. So there is a process already that these female agents only provide the consent regarding the customer data and all. So is it at all abiding by the rules and all?
I think it would be better, again, in this circumstance, and I'm sure there are nuances but I think as a point of first principles, I would suggest that it would be better to get the consent directly from the individuals themselves and not from their agents.
Thank you.
Okay, good.
Thank you, Jayraj. I'm just going to take a couple of questions more, and then you can raise your hand and unmute yourself and ask so that we get to talk to you and we can make it more interactive. Shashi has a question. What type of policy should be in place, should be put in place by an NGO for privacy of data?
Shruti, why don't you take this one? I've monopolized this, so why don't you go?
Sure. So at least under the current regime, the SPDI rules provide for what the contents of the privacy notice need to be. So practices and policies, disclosure of information to third parties, the type of personal information being collected, including SPDI, the purpose of collection, and what are the reasonable practices and procedures for security that you are adopting to safeguard that information. And so far as the DPDP Act is concerned, it would, of course, include the information that is being collected and the purpose, the manner of exercise of the data principle of their rights under the DPDP Act, and the manner in which they can make a complaint to the Data Protection Board. However, of course, we would also need to wait for the rules to see if there are any particular formats or any additional requirements that the rules may add, just by way of procedural just procedural factors that may be added.
Thank you. I saw a few hands that were raised up. I think Satya, you had raised your hand earlier. And please feel free, everyone, to just interact, ask your questions. Please tell us where you're from and which organization you're working for. That'll be great too. Go ahead, Satya.
Thanks, Priya. I am Satya from Opportunity Foundation Trust. We are an education focused NGO. So my question is, we have our scholarship beneficiaries who are girls. We have been providing scholarship for last 10 years, and yes, we do have data of all our beneficiaries. So, so how long can we retain that information, or is it okay? Like everything is in hard and soft copy both. The basic details like name, parent details, and date of birth, age, and college where they have studied, where they graduated, all that information we have. So, and yeah, we have a consent from them when we are collecting the data. It is filled by the candidate itself. But like I said, it's 10 years old. Like now I just want to know, after hearing all this, like how long can we retain, or is there any other thing that we need to do? Thank you.
Anuj, would you want me to take this?
Yes, please. Yeah, sure.
Okay, so under the current regime, at least, Satya, because none of the data that you described seems to us to be SPDI as such. is personal data but not SPDI. So that at least under the current regime, there is no requirement to retain it only up till it's necessary. But because the DPDP Act will be operationalized soon, it does provide that you can retain it till the earlier of withdrawal of consent. So if any beneficiary withdraws their consent, then you may need to erase it. Or if it's no longer necessary for any specific purpose. So if you do need to retain that beneficiary data for purposes such as ensuring that you have a track record of how your beneficiaries are doing over the years, then you may need to retain that data, and you'd have that of course to go ahead.
Yes. And like whenever we go for any validation or FCRA renewal or something, they definitely need previous student data and they want us to contact them.
Yeah.
They want to talk to the beneficiaries. So
So-
as of now, all of them, like many of them in past 10 years old, all of them have graduated and they're working in different organizations now.
Yeah.
As of now, like, they're not active with us, but whenever it is needed, it's again a compliance issue only. Like whenever someone wants to meet the beneficiaries, so that's when we will definitely need their information.
So in fact,
So-
FCRA. Sorry, Anuj.
I was going to say actually, so because this is data that you've already collected, when the new law comes into force, if you want to continue to use this data, you will need to get the consent of all these beneficiaries and say that we have this information. We need your clear, unambiguous consent to continue to retain it, and we will be retaining it for these purposes. And you have to specify what purposes you will be using it for.
Oh, okay, great. Thank you. Thanks.
I know we are running out of time, and I saw one question from, I think, Praveen, who said that if there are any further questions, could we, will we be available to help? Yes, please feel free to channel your questions through Priya at iProbono, and we'd be very happy to answer them. I will say that this is a very, very new field and it's moving very quickly and the rules haven't come out. So, we really appreciate the questions, and frankly, it also helps us evolve our thinking. This is a very new area of law for all of us. So please feel free to reach out with questions as and when you have them. This will help us refine and evolve our thinking as well. I'm afraid I've got a very hard stop and I'm going to have to leave, but I would just like to say thank you all for your patience, and thank you again, Priya and the iProbono team, for organizing this. And I would in particular just like to thank my colleagues Shruti, Antara and Mehak for the amount of effort that I know that they've put into preparing for this and presenting this to you all. So, I'd like to just thank them in particular. And I'm going to drop off now. I'll leave you, Priya, to perhaps close. But please, as I said, please feel free to send additional questions through and we'll do our best to answer them.
Thank you so much, Anuj, and the whole team of Touchstone. I know Ritu has her hands raised up, so if Shruti want to take one last question, and
Sure.
then, everyone else who wants to reach out for any specific legal advice on this or any questions, I'm going to just drop in our details on the chat box. But one last question from Ritu before we sign off. Go ahead, Ritu.
So my question is, if you're taking sensitive information from children.
Sorry, Ritu, you're not audible.
Oh, sorry, I've unmuted myself.
Can
hear
you
me
be a
now?
little bit louder?
Okay. Is this okay?
I'm sorry, I'm still not able to hear.
Maybe
Like,
put your question on the
I'll
chat
take
box
my-
and I'll take it.
Priya, you're on mute.
Thanks. And in the meantime, everyone who's logged in, please scan this QR code. It will link you to a feedback form, and we'd love to hear your thoughts on what you felt about the session. Of course, please keep in mind this is first of many conversations we'll have around this topic because it's an evolving law. Like Anuj said, we still have to get the rules and regulation and see how it actually pans out. So this is one of the first conversations we have around data protection. We'll be happy to organize more such sessions and of course create resources for you as well. Ritu, her question is, can schools be authorized, can be the authorized guardian even if the consent from the parents is not taken?
This is not, I'll be very honest, not very clear because it just says parents or lawful guardians.
Hmm.
So I'm not sure if under law a school can be authorized as the guardian. I assume it will be whatever other law mentions what guardians can be actually.
Thank you so much, Shruti. With that, I am so sorry we can't take more questions, but it's been great interacting with you. I'm going to just leave some details out on the chat box. So you can reach out to us with your questions on this seminar or if you need any legal advice or support for your NGO. Thank you so much for joining. Thank you so much to all the members of the Touchstone team. It's been great and very informational.
Thank you, Priya, and
Yeah.
thank you to everyone for being so participative. It was super.